everyone. I'm Rita Peters. I'm the Senior Vice President for Legislative Affairs with Convention of States Action, and welcome to a really special edition of COS Live. We are calling this one COS Live Goes Undercover, and you are going to just love what we have to show you today. We're going to look at some hidden camera footage that one of our young leaders captured while speaking with a staff member of the John Birch Society, a radical fringe group on the right that has been an obstacle to the Article 5 movement and has helped to preserve the status quo in Washington, D.C. This will be a really good primer for you on what they are telling people, in particular, what they tell legislators in trying to dissuade them from using Article 5, the Constitution's solution to federal overreach. What misleading tactics do they use? Sometimes, as we'll see, they even contradict themselves. I think you're really going to enjoy this program, and I'm so pleased to introduce Kristen Stanchu. Kristen is the Senior Coordinator for the Emerging Leaders Program at Convention of States Action. Kristen, welcome.
Thank you, Rita. It's so good to be here with you.
Now, you went undercover at the Texas GOP convention with a representative from the John Birch Society. Tell us what happened, who is this guy, and what was your reasoning for doing this?
Yeah, so the guy I spoke to was a JBS representative. He appears to have held multiple roles with JBS in the past, but most recently he appears to be their development officer for some of the southern states, Texas, Oklahoma, Arkansas, Louisiana. And I was really just there to have a conversation. I was playing the part of a curious, unsuspecting observer who just wants to learn more about Article 5. And that's where a lot of people are. They just want to learn more. And I wanted to hear firsthand what they would tell people who are just looking for the truth and the facts. I didn't make any arguments. I just tried to ask questions. And what they said was very revealing.
Yes, and our audience is going to see that in just a few moments. So this was a 30-minute conversation you had with this gentleman. We're not going to show the entire thing, but we did choose 6 representative clips that we want to look at. Some of these are very common JBS talking points and are, as I said, used frequently to try to discredit Convention of States volunteers and to try to spread fear about this constitutional process with legislators who are considering our legislation. Some of their claims are just flat out, demonstrably false, and we're going to show you exactly why. So let's go ahead, Producer G, and show this first clip number 1.
The only power the states have is to apply to Congress. Okay? So states don't convene as a convention. States don't call the convention.
Well, they submit the application.
All they do is apply.
And Congress must call, right?
Correct.
Yeah. Yeah.
And then once that Congress calls it, because the call is a term of art, it's a legal term. In essence, those who call a convention or call a meeting, they're the ones that organize it. So Congress sets the date, time, place, and the delegate selection because there's no delegate selection.
Well, states select the delegates.
No, they don't.
Where do you get
Congress decides it. Well, if you read Article 5, there's no provision under Article 5 for delegate selection.
There's case law, though, isn't there?
No, there's no case. Right case law doesn't apply.
Case law doesn't apply?
It does not apply.
Why not?
Because you're dealing with sovereignty. You're not dealing with legality, you're dealing with sovereignty. See, the convention is a body of delegates that are sovereign representatives of the people. See, legislatively, when you go through Congress can propose amendments, okay? And then they submit it to states for ratification. When a convention proposes amendments, the power of the delegates in the convention is not subject to the federal authority. It is a supranational body.
But it's still like any amendment, like let's say Amendment X, goes through
Correct.
convention, it's voted on by the delegates, it's still not in effect until it goes through the whole process of Article 5, right?
Correct.
By being ratified by
That's
the states.
correct. But the power of the convention is not just for amendment, to propose amendments. They can propose an entirely new constitution.
Okay, so this is a really long clip. There is a lot in there. I think this is our longest clip. We're going to try to break it down a little bit. And I want to start by backing up to the beginning where he actually said, I listened to this multiple times, he actually said, states don't convene as a convention. Kristen, at this point, were you thinking that you were in the Twilight Zone?
A little bit. When he was explaining it, he really just took the states almost completely out of the equation. And then he made Congress this all-powerful body in terms of controlling and managing the process of an Article 5 convention. It was so strange.
It was very strange. And, I do want to be gracious and give credit where credit is due. He did get a couple of things right. The call is, in fact, a term of art in Article 5, as he said, and it does refer to setting the time, place, and initial location of the meeting. That much was good. But then he said, Congress selects the delegates, and he just says it like it, that's a fact. And Kristen, you very astutely asked him where he gets that. And all he said was that Article 5 doesn't give you the answer, right?
That's right. He points out that the text of Article 5 doesn't specify how delegates are selected, but then he just jumps to the conclusion that Congress has the power to select the delegates. And then when I asked him where that comes from, I asked him about the historical precedent from the numerous interstate conventions that have been held throughout American history. He says something that I didn't expect. He just says that case law doesn't apply. And all of that precedent and history just goes right out the window.
Yeah, so that was definitely a strange statement too. Case law doesn't apply, just kind of randomly pulled out of the air. But let's address the historical practice because that is what is most relevant on this. We know from historical practice that the states select the delegates who represent them at the convention. It's actually pretty silly to think that the institution that calls the convention selects the delegates. Virginia called the 1787 convention, but did it select the delegates from Pennsylvania and Maryland? Of course not. He's also completely wrong in saying that the delegates are the sovereign representatives of the people. No, they're the representatives of the states that applied for the convention. And again, we know this from history and from the fact that at every interstate convention, the state legislatures choose their delegates and then give them precise instructions for what they're allowed to agree to on behalf of the state. In the law, we call this agency. The delegates act as the legal agents of the state legislatures with only the amount of authority that the state legislatures give to them. So then, Kristen, he hit you with the power of the convention is not just to propose amendments. They can propose an entirely new constitution. What were you thinking at that point?
That one threw me for a second, not because I haven't heard it before, I've heard the argument before, but hearing it in real life, I was like, whoa, where did that come from? Like, are we reading the same Constitution? Because I don't see that when I read Article 5.
Of course not. Now, let's see one more clip where he goes further into this wild theory, and then we'll talk about it.
If Congress wants to do whatever they want to do, they can do that. But if it goes back to the states, then it's up to the state legislatures to choose whether they propose, support the amendment, or if they want to deny the amendment.
Well, they could decide
The state
whether
legislatures, right.
up or down, but
Right.
Congress decides which mode ahead of time. So if
But regardless, it still goes back to the states, correct?
only if amendments come out of the Constitution, of the convention.
Right, so if an amendment is voted out of convention, is what I'm saying, and it comes
Right.
to the
But if a new
ratification process.
Constitution comes out of the convention, that Constitution will have its own mode of ratification.
But where in Article 5 does it allow for a new constitution to arise out of convention?
It does.
So it's not an option.
Well, it is, because you have to understand the power of a convention. See, the convention is a sovereign body, and the power of the convention doesn't come from the Constitution. It comes from the Declaration of Independence, because the Declaration of Independence says it is the inherent right of the people to alter and abolish their government.
Here we go. So I want to be generous again and start off with the bit that he got right, which is that Congress does get to decide under Article 5 between the two modes of ratification. It can be done by the state legislatures or by ratifying conventions in the states. But then he goes back to this wild speculation about a new constitution coming out of the convention. And Kristen, I love how you just straight up asked him, where in Article 5 does it allow for a new constitution? So you caught him there, didn't you?
You're right. When I asked him that, he said it doesn't, because it's not there. But then he starts talking about this power of the convention. And this part really baffled me because he kept bringing it up. And it was almost as if the power of the convention is this nebulous force that can override the will and reason of the American people, and that as soon as these delegates gavel into convention, all process, all law, all of American history just ceases to exist. It was really bizarre.
Yes, it is bizarre. And then he delivers the real shocker when he tells us that the power of the convention doesn't even come from the Constitution. It comes from the Declaration of Independence, he says. Kristen, what were you thinking when he said that?
That took me a second to wrap my mind around, but eventually I saw how he was convoluting the state of the American system in 1787 and where we are now, the role of the Declaration and the Constitution. I mean, you take 1787, there was no Constitution, there was no means enshrined in law for amending the governing document, which was the Articles of Confederation. So the natural right of people to alter and abolish their government came into play. But today, I mean, we have a constitution, and in that constitution, we have Article 5, which is something the founders didn't have. We have a process by which we can alter our existing constitution by proposing amendments to that constitution. And so he's right in that the Declaration is the underpinning of the Constitution, but the Constitution builds upon the Declaration. The Declaration is the picture frame, the Constitution is the picture. The Declaration doesn't replace the Constitution, and it certainly doesn't nullify or reverse actual processes laid out in the Constitution like Article 5.
You are right on, Kristen, and I love your analogy there about the relationship between the Declaration and the Constitution. Now, I'll tell you, I always find that the further off base someone is with their argument, the harder it is to respond, because where do you even start? With this argument, which I have heard once before, I like to ask the person, why would we even bother going through the process of an Article 5 convention if we wanted to invoke the right of the people to alter and abolish our government? That right is fundamental, and it's not predicated on the very difficult process spelled out in Article 5, which is all about proposing amendments to the Constitution. There's simply no link between an Article 5 convention and the abolishment of government as referenced in the Declaration of Independence. An Article 5 convention has one power that does come from the Constitution, and that power is to propose amendments to this Constitution, the one that we already have. Okay, so that was a crazy, off the wall thing to have to listen to. Let's go on to our next clip, Producer G.
So I have a question. So you said, that because of the sovereignty and how it all works, that the convention is, superior to, the Congress and whatever else is going on. So my question is, if the power comes from the people and not from the Constitution or Congress or any other such body, then you say that Congress will be able to control it. Congress will be able to appoint delegates. Congress will be able to say what method.
They don't necessarily appoint delegates. I mean, they can, but they have the power under the necessary and proper clause to decide the delegate selection process because it's not provided for in Article 5.
But because convention is sovereign, then you're saying that supersedes whatever Congress does, because Congress is now no longer...
Congress decides the delegate selection, but once the delegates come together, when they come together as a convention, that's when they have the power. So that's why I keep saying there's no convention of states. It doesn't exist. Does that make sense? The delegates do not come from the states. The delegates come from whomever Congress decides.
Yeah, that's right.
Because the necessary and proper clause gives Congress the power to make laws that are necessary and proper to carry out the powers of the convention legislatively, the first 18 enumerated powers, or any other powers.
You really caught him in his own tangled web of confusion here, and I love it. You're pointing out the inconsistency of his claiming that the convention has this amazing sovereign superpower, but also that he's saying that Congress organizes it and controls the process. He doesn't really seem to get it, does he?
At this point, when I asked this question, I was confused too, because on one hand, he's saying that convention is this ultra powerful, unstoppable force that no one can touch. And then the next minute, he's saying that Congress is managing everything and deciding the details of the process. And you can't have it both ways.
So he very painfully backpedals a little and says that Congress decides the delegate selection. And then once the delegates come together, they morph into a superpower. Okay, I can maybe follow that. But again, as you pointed out earlier, he has zero basis for his conclusion that Congress decides the delegate selection. And in fact, that goes against every precedent we have in American history, and we have many. Then he says, the delegates do not come from the states. What? Kristen, how did you hold it together when you're listening to this? And how did you abide his preachy superiority as he's saying all these things that don't make sense?
Well, I guess my poker face has improved in recent years. But at this point, I think I was really in the zone. And I just wanted to unravel this thread and get to the bottom of this argument because it made no sense. And when he said the delegates don't come from the states, I really wanted to ask, well, where do they come from? I mean, do you really read Article 5 and then walk away thinking that Congress can just pick delegates out of a hat and send them to a convention?
So his alleged rationale for his theory is the necessary and proper clause. And I've found that's a common strategy of COS opponents. Their argument goes, blah, 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 necessary and proper clause. But here's the problem. He hasn't done even a little bit of homework, apparently, or he would know that there is a federal court ruling that specifically says that Congress can't use its power under the necessary and proper clause, which is in Article 1 of the Constitution, when it comes to Article 5 of the Constitution. And we're really familiar with this case because, in fact, it was argued by our very own senior advisor and co-founder, Michael Ferris. Producer G, I don't know if you have that quote that you want to put up. There it is. So this is taken from the federal court opinion. You can see the highlighted portion clearly says, thus, Congress, outside of the authority granted by Article 5, has no power to act with regard to an amendment, i.e., it does not retain any of its traditional authority vested in it by Article 1. So the necessary and proper clause is in Article 1. And here we have the court telling us that when Congress exercised its role, its authority under Article 5, Article 5 controls. It doesn't get to use any of its powers in Article 1 of the Constitution. Okay, this next clip is shocking. Let's go ahead and watch it.
Now, one thing that took place in 2011 is a man by the name of Rob Natelson. He's a professor in Montana. Kind of I call him a false scholar, but he in 2011 wrote that the Constitutional Convention language is very toxic. You can't get a convention called using that language. We have to change the name. So he said, among other things, we should call it a convention of the states. 6 months later, the Convention of States Action, formed by Mark Mecklenburg, were established. Based on that, that language of Convention of States has never been used in modern times. I mean, Patrick Henry used it in one of the resolutions, but, Jefferson called the convention a continental convention. Madison called it a general convention, but everybody knew back then that it was a convention. Does that make sense?
Okay, Kristen, what were you thinking when you heard this guy call Professor Rob Natelson a false scholar?
All I can think is just because you label experts you disagree with as false scholars doesn't make it so. From what I've seen, Professor Natelson has done extensive research and deep study, not just into constitutional issues, but Article 5 in particular. And labeling all of that as false in one fell swoop without a shred of evidence is laughable.
So I just want to review for our audience a smattering of the credentials of Professor Rob Natelson. He was a law professor for 25 years. He's currently the Independence Institute's Constitutional Studies Center head, senior fellow in constitutional jurisprudence, and he's also a contributor for the Epoch Times. His scholarly works have been repeatedly cited by the U.S. Supreme Court, federal appeals courts, and at least 16 state Supreme Courts. He is actually one of the most frequently cited constitutional scholars by the U.S. Supreme Court. His list of published peer review articles, I stopped counting at 20. It's really long. And not insignificantly, he wrote the only existing treatise on Article 5 entitled The Law of Article 5. In fact, Rob Natelson is the country's leading scholar on Article 5. So to be quite frank, if you call Rob Natelson a false scholar, you have no credibility left with me. Kristen, did this guy ever tell you what his credentials are?
No, he did not. And I have to say, I had to do a pretty extensive search online to even get an idea of his role at JBS. And I didn't happen to come across any scholarly works, Supreme Court citations, peer-reviewed articles, or Article 5 treatises during that search. So I don't think that he has a leg to stand on compared to Professor Natelson.
Yeah, that's right. And this actually brings up a really important point that I want all of our audience to be aware of. And that is, it's really important to know what someone's actual credentials are when they claim to be a constitutional scholar or a constitutional expert. Because I'm sorry, but just reading the Constitution, owning a copy of a pocket constitution doesn't make you a constitutional scholar or a constitutional expert. So this is a situation where understanding what someone's credentials and training are really is important when you're trying to figure out who's credible and who can be trusted. So to address the substantive point he makes in this clip, I think we should let the historical documents speak for themselves. So Producer G, if you can show us the very first application for an Article 5 convention submitted by my home state of Virginia, refers to it as a convention of the states. You see it right there. The words are a little bit harder to read because they're old, but it definitely refers to it as a convention of the states. The Supreme Court has also referred to an Article 5 convention as a convention of the states. And there we have it. Thanks, Producer G. It's in Smith versus Union Bank of Georgetown, all the way back from 1831. This is a Supreme Court decision, and you can see the highlighted language right there where the Supreme Court refers to that process as a convention of the states. So I love Rob Natelson. He's one of the smartest people I know, but he can't take credit for coining the phrase convention of the states. It's not a made-up phrase. Sorry, this guy's just flat wrong about that. Okay, let's go on to the next clip.
Why do you think the founders in the last minute, added Article 5 to even allow the
Well, the
process
reason
for
why
the
is
states
because
to
they
apply?
said it. If you look at Madison's notes, they basically said it. They said it, instead of leaving a change of government in the hands of chance and violence, they understood the sovereign power of the people, that they have the right to alter and abolish the government. So instead of letting it go to chance and violence, let's just give them the opportunity to amend it. That's the only reason they put it in. And one of the reasons George Mason wanted it to be in why he suggested it was not, it's not because in case the government became tyrannical, you want to have an ability to rein it in. That's not what he said. What Mason said was specific to amendments. He said, if we don't put, because they wanted only Congress to be the body that proposed the amendment. He said, well, you can't let Congress do it, because if Congress decides they don't want to do it, then the people don't have an alternative. That's why they have it. Not to rein in if the government, if it became tyrannical, but to allow the people to propose amendments if Congress would.
So you're saying it's not because they realize that Congress would never rein itself in?
Correct. That's not what Mason said. You read what Mason said in Madison's notes. That's exactly what he said.
Okay, so I want to be generous again and point out that he started to get it right when he said that the founders wanted the people to have an alternative if Congress wouldn't propose amendments, right? Did you think he was finally getting it right?
Yes, at this point, I was thinking, great, we finally agree on something. And, he'd finally gotten something right. But unfortunately, that didn't last long.
Yeah, because in his next breath, he says, but it was not to rein in the government if it becomes tyrannical. And he wants us to read Mason's notes. So let's do it. This is what Mason's notes say, Producer G. So, referring to the original version of Article 5, it says, Colonel Mason thought the plan of amending the Constitution exceptionable and dangerous, as the proposing of amendments is in both the modes to depend, in the first immediately, in the second ultimately, on Congress. No amendments of the proper kind would ever be obtained by the people if the government should become oppressive, as he verily believed would be the case. So you can see from the next lines here that Article 5 was amended to add the convention process in case the government should become oppressive, right? It's right there. Kristen, do you think he thought you didn't have a copy of these notes, or?
I don't know what he was thinking, but as he was saying that, I remembered this part in Madison's notes, and I was excited that he was challenging me to go back and read them, because I was pretty sure I knew what he said, and it didn't line up with what this gentleman told me.
Yeah, he just probably needs a refresher. Okay, and I want to show one other quote. This one is from Alexander Hamilton in Federalist 85, discussing the convention process. And he says, we may safely rely on the disposition of the state legislatures to erect barriers against the encroachments of the national authority. So we do know that the founders intended the states to be able to use the Article 5 convention process to stand up to federal overreach. It's right there. Let's see one final clip.
Hillary Clinton and George Soros and others are also not fans of Convention of States or Article 5. What do you make of that association?
Well, it can be done. It's the left that's always pushed it. And you have...
That's always pushed Article 5?
A convention. And
But Hillary
Article 5
Clinton and Bill and
Right.
George Soros are against it.
No, they're not. They're for it.
They're for a convention of states?
Oh, yeah. Soros funds, Wolfpack funds a lot of these other leftist groups because you have leftist groups that have been calling for a convention for a while, and then you have convention of states that say that they're on the right, but it's left-wing billionaires that are really funding them. Yeah.
I would check on that because I'm pretty sure that George Soros is also against the convention of states, but you can check that out on your own.
It's always been a leftist movement, and it's always been the conservatives that have stopped it. So that's why they did the name change, because they wanted it to appeal to conservatives so they can have a bipartisan effort to get a convention called. That's the history of it.
So he insists that it is the left that has always pushed for an Article 5 convention and that it is, in fact, left-wing billionaires like George Soros who are funding this effort. What were you thinking, Kristen?
Well, I've heard this argument before, but no one has said it to my face before. So this is one point where I was struggling not to laugh and really push back because I know the people leading our organization. More importantly, I've met many of the grassroots who are really doing the legwork and calling for this convention. And I can tell you, they have about as much in common with George Soros as the founding fathers themselves did. The notion that George Soros supports the idea of calling for an Article 5 convention might have been the most ridiculous thing I heard that day. And that's saying a lot.
Well, let's just look at some of the facts here. In American history, hundreds of applications for conventions have been submitted. Of course, the reason we haven't had a convention yet is because there have never been 34 applications for a convention on the same topic, which just proves that the subject matter limitation by the states is controlling. But of the hundreds of applications that have been submitted, the ones with the by far highest totals are the applications for a balanced budget, for limiting federal power, for term limits. Those don't sound like leftist causes to me. On the other hand, there is at least one leftist effort for a convention. It's to repeal the Citizens United decision. They have a total of 4 applications pending. So not a super popular push, apparently. But let's look specifically at the claim that George Soros is funding the Article 5 efforts. Because, Kristen, as you know, we hear this a lot. Everywhere we go, we're, told that George Soros is the ones paying for the Convention of States effort. I can tell you definitively that he has never contributed a penny to our organization. I can also tell you that he does contribute heavily to many of the hundreds of leftist organizations that publicly oppose all Article 5 efforts, including Common Cause. So interestingly, Kristen, that puts this guy on the side with George Soros, Common Cause, Planned Parenthood, the Sierra Club, Greenpeace, the AFL-CIO, the League of Women Voters, and a whole host of other leftist organizations that oppose Convention of States because they don't want to see power decentralized. Now, as we close, I just want to get your overall take, Kristen, on your encounter with this JBS representative. What did you think of his arguments and what did you think of his manner?
Yeah, I have to say, I'm very glad that he engaged with me and answered my questions. It was a really interesting conversation. And although I expected many of the things that I heard, a little part of me was still naively hoping to get the truth. But Rita, truth is not what I heard at that booth. I heard myths, I heard lies, but I have to say what I really heard was fear. Fear at the very idea of using the Constitution to save the Constitution, fear at using this emergency tool that the founders gave us to save the Republic. And I don't personally know anyone at JBS. I won't make any personal judgments about anyone, but I will say that as an organization that claims to respect and defend the Constitution and the principles established by the founding fathers, they seem to have forgotten that we are not descended from fearful men. Instead of looking at the facts and the history and summoning that same fortitude and courage exemplified by our founders to save our country, they weave this intricate and elaborate web of confusion laced with fear, but that's not who we are. We are in a critical time in our nation. We don't need summertime soldiers or sunshine patriots. We need to embody the stalwart resolve of men like Thomas Paine, who said, "Tyranny like hell is not easily conquered." Yet we have this consolation that the harder the conflict, the more glorious the triumph. So I'll just say, we don't need their fear. We need solutions and men and women who are steadfast enough to carry them out. And the founders gave us a solution in Article 5, and it's up to us to use it.
Kristen, thank you so much. This was an enlightening undercover effort that you engaged in, and you did an amazing job just drawing him out and asking the questions to really get him to expose, what the convoluted thinking behind the JBS position on Article 5 is. So thank you so much, Kristen. And I also want to thank our audience for being with us. If you want to learn more, get the facts at conventionofstates.com/facts. You'll also find just a wealth of information, more answers to your questions there at conventionofstates.com, as well as how to get involved. So thanks everyone for watching. Don't miss a special edition of COS Live next week, where Andrew Luce and I will break down a recent hearing of the Ohio legislature regarding Convention of States Actions resolution. You won't want to miss that. Go to conventionofstates.com/COS Live to tune in. Thanks everyone.